some hitches, obstacles on the way, but I think we've recorded a tremendous success in this journey. And I pay glowing tribute to some of my colleagues here. The National Secretary of the party, Mr. Ibrahim Mani, is here. The Deputy National Secretary, Chief Godwin Odo, is here. The possible to steady the ship of APGA in the right direction, knowing, or of course, paying quite some recognition of the issues we've had in the past. But so far, so good. At least they're having this number of NWC members on a very short notice. I think it was less than 24 hours that we organized this press conference, which, of course, in due course, I would say what necessitated the emergency press conference. But I welcome each and every one of you here, and from my heart, I say a very big thank you for coming on a very short notice. I must say that there are some issues that necessitated today's press conference. And if not for anything, there is need, an urgent need for us to put the record straight. We owe it a duty and a responsibility for us to inform Nigerians about some recent happenings in the leadership of APGA. Like we've always maintained, right from the times of my predecessor, Dr. Victor Ike Oye, APGA does not have any faction. And we say that emphatically. APGA has no faction. The only way you can assume leadership of a political party, the Supreme Court has said it in a plethora of authorities, is through a national convention duly monitored by INEC. Of course, INEC is a creation of the Constitution of Nigeria and the Electoral Act. And being the regulatory body, they are duty-bound, even more so by the new Electoral Act, which has now made it mandatory that if you do not give INEC notice of your convention and if they do not attend, then any decision reached at such a gathering is null and void. That is the express provision of the Electoral Act 2002, I think section 82. Yes. Now, so having said that, I am a product of a national convention conducted on the 31st day of May 2023, where I, alongside 30 other members of the National Working Committee, were unanimously elected by the National Convention of APGA. That convention was duly monitored by INEC, a team of INEC officials led by no less a person than a national commissioner, then by Sir Festus Okoye. He led a team of other staff from the EPM and other, even the legal and other departments in INEC, and they were there in Oka at the International Convention Center. The convention was witnessed by the national leader of the party and some other key members of the National Convention of the party. And there, some decisions were reached. The majority of them, or the major one, was the election of the new NWC of the party that will lead the affairs of the party for the next 4 years. Now, this fact has become imperative in view of some misinformation that we have seen. One Edozie Njoku, I think he called a press conference. Now, for whatever it is worth, if Edozie Njoku wants to be a member of APGA, he knows what to do. APGA as a political party, our doors are open. If you want to become a member of the party, you do a simple thing. You go down to your ward, register as a member of the party, and pick up your membership card. If you want to run for any office, you will wait for elective national convention or congresses. So officials of the party in line with the constitution are elected at either congresses or the National Convention for National Working Committee or national officers of the party. You don't bandy court processes about. I remember, I think it was the case of McAfee and Sheriff. The Supreme Court said that the court do not coronate national chairmen. It is not the duty of the court. It is the duty of the members of the National Convention at a duly convened National Convention that have the powers and authority to elect members of the National Working Committee of the party or national officers of the party. And nothing you say from here to Jericho is going to derive from that fact. And like I said, I was a product of a National Convention on the 31st of May, 2019. I know most of you here, 2023, I know most of you were there. You attended that national convention. The video clips are there. We have equally applied to the Independent National Electoral Commission for the issuance of the official report of that convention, and we have the official report of the convention. It is here. So, on Friday, like I said earlier on, Edozie Njoku, I heard he addressed a press conference because my attention was drawn to it, where he said all manner of things. And that is the major thing that necessitated this press conference. For first of all, like I said earlier on, we need to set the facts straight so that you do not be confused and you go out there and inform Nigerians about the true position of APGA. If you recall, sometime in 2021, there was a judgment of the Supreme Court. I think it was delivered either on the 10th of October or thereabout. I can't really remember the date, but it was in October 2021, where the Supreme Court dismissed the appeal of one Chief Jude Okeke. And of course, it was a journey that started somewhere in Jigawa, where some persons went to Jigawa High Court and got an order that Jude Okeke was a national chairman of APGA. Of course, the national chairman of APGA at that time was Ozombu Dr. Victor Ikoye. And just like I talked about emerging from a national convention, he in turn emerged from a national convention held on the 31st of May 2019, monitored by a team of INEC officials led by then National Commissioner Professor Antonia Simbine. The records are there. So after that convention, when they went to get that judgment, of course, as a person whose office, because even in the suit filed in Jigawa, he was not joined as a party. And he appealed to the Court of Appeal as a party interested. And with the leave of the Court of Appeal set aside the decision of the lower court. In fact, the Court of Appeal found as a fact that as at that date, there was a subsisting judgment of the Anambra State High Court affirming his election as the national chairman of APGA, I mean Dr. Victor Ikoye. And in view of that judgment, that he remained national chairman of APGA. It was a crucial finding made by the Court of Appeal. They appealed further to the Supreme Court. The Supreme Court dismissed the appeal and affirmed, because it's very key, the Supreme Court affirmed the judgment of the Court of Appeal. The Supreme Court panel was presided over by Honorable Justice Mary Odele, retired. Then, almost 2 years after, or I think a year plus after, they started bandying one document which they said that it was a corrected Supreme Court judgment. And if you see the judgment, incidentally, I don't have it here, what they claimed at that time that it was a corrected Supreme Court judgment, they had deleted the name of Chief Victor Oye as the second respondent on record at the Supreme Court and inserted Chief Edozie Njoku. Of course, we know. Anybody that is a lawyer or that knows one or two things about court proceedings and court processes, we know that there is no way a party on record will cease to be a party on record. It's either the court strikes out your name or your counsel, or if with the leave of court, that person is withdrawn as a party. It must be either on the application of the personality that has been sued or on any other application, but there must be a formal order striking out that person's name as a party. You don't unilaterally delete a respondent or a party's name from the proceedings of court. And that's what they did. Of course, the police, we wrote a petition to the police then. I was the legal advisor of the party then. The police investigated and found him culpable. And he was charged before the FCT High Court, presided over by Honorable Justice Madugu at Buhari. As I speak to you, that charge is still pending. Now, on the 24th of March, upon his application, the same Edozie Njoku, pointing out what we call a clerical error or an accidental slip. Accidental slip in the sense that in a particular page of the judgment, his name was supposed to be mentioned instead of Oye, because the suit at the Jigawa that led to the appeal by Oye in Kano, he was a person that was allegedly suspended as national chairman. So, when the Supreme Court was now reviewing the background fact, instead of mentioning his name, they mentioned Oye's name. So he brought an application. Of course, the lawyers agreed that there was a clerical error, because there was never a time Oye was mentioned as having been removed in Jigawa. The person they alleged was the national chairman was Edozie Njoku. That was the allegation of the plaintiff. And the allegation of the plaintiff does not equate to an order of court or to a proven fact. It is just like saying that anybody here, someone files a suit. We know that the governor of Lagos State is Honorable Dr. Sanwo-Olu. Then someone says that someone files a suit and says that I am the governor of Lagos State. Does it make me the governor of Lagos State? No. That was exact. So you filed a suit and say that Edozie Njoku was a national chairman and you removed him. Does it make him the national chairman? It is just a set of facts. And it can only be established if proven by fact or by evidence. If you say that Mr. Man is a national chairman, present the document or the report of his convention from INEC. That's the only way you can prove that someone is a national chairman. If you want to know the managing director of a bank, you go to CBN. You get the official records of CBN showing who the directors of that bank are. It's not something to prevaricate about. So when they brought that application, the Supreme Court said yes. There was an error. Nobody mentioned Oye. His name was never mentioned in Jigawa. So it was your name. But essentially, the judgment of the Supreme Court was that the Jigawa High Court lacked the jurisdiction to entertain the suit ab initio. That was the judgment of court. And the next thing, they went about town with the judgment of the Supreme Court, saying that the Supreme Court has deleted Oye as national chairman, and that has now, in Oye's place, replaced him with Edozie Njoku. Of course, INEC was a party to all these proceedings, because in due course we'll come back to their campaign of calumny and blackmail against the INEC chairman, Professor Mahmood Yakubu. INEC has a team of lawyers. I think last count, INEC have about 4 senior advocates. And it's not an institution that you can probably misguide or mislead. They know the position of the law on key issues of fact and law. So INEC had, of course, they were parties to the proceedings right from Jigawa to the Court of Appeal to the Supreme Court. And they were equally parties in the corrected Supreme Court judgment. And the Supreme Court stated expressly, even in the ruling correcting the judgment, that its correction does not in any plausible way vary or substitute the operative part of the judgment, stated clearly on the body of the ruling of the Supreme Court. Now, subsequently, because it is very key, and that is why we need to know the various judgments that has arisen even after the Supreme Court ruling of 24th of March, because the Supreme Court ruling correcting the error was delivered on the 24th day of March 2023. One Chief Chekwas Okorie, I have the document here. This is the judgment of His Lordship, Honorable Justice James Omotosho. Now, one Chief Chekwas Okorie and some other persons instituted an action claiming to be duly nominated candidates of Edozie Njoku. What was their claim before the court? They said that by the Supreme Court ruling, which has now removed Oye as national chairman and replaced him with Edozie Njoku, that the appropriate chairman, first of all, they said that the chairman of the party was Edozie Njoku, and that he alone had the powers and authority to validly nominate candidates on behalf of APGA. That was the crux of this suit. Now, let me read a portion of the judgment of Honorable Justice Omotosho. And he said, it is clear from the above decisions of the appellate court, this is at page 35, that the validly elected chairman of the party is Chief Victor Oye. That is Justice Omotosho. This judgment was delivered on the 28th day of March, 4 days after the suit, because the hearing in this case was done on 27th of March. And the judge had to deliver judgment in 24 hours because of the time limit. You know, pre-election matters have the constitutional time frame of 180 days within which the court must hear and determine the matter. So, and I think it was supposed to elapse on the 29th of March. So the court did the hearing on the 27th and took the pains to deliver the judgment the following day. And of course, the ruling of the Supreme Court was tabled before the court. It was admitted in evidence. Now it says, contrary to the claim of the plaintiffs it's very key. Contrary to the claim of the plaintiffs that the Supreme Court mistakenly put the name of Chief Victor Oye instead of the name of Chief Edozie Njoku, it is apparent to this court that the correction of a slip in a name by the Supreme Court has no effect on the validity of the judgment that confirmed Chief Victor Oye as national chairman of the party. How can correction of accidental slip in a body of judgment affect it when the Supreme Court clearly in its conclusion affirmed the judgment of the court below, which is the Court of Appeal, Kano? Now, going further, this is now at page 37 of the same Justice Omotoshaw's judgment. He says, the judgment of the appellate court on the issue of chairmanship of APGA still subsists, and there is no evidence that they have been set aside. Consequently, the Chief Victor Oye-led NWC, very key, the Chief Victor Oye-led NWC is the authentic committee recognized by law. This same committee is the one authorized to nominate and forward the names of candidates to the first defendant. The first defendant here is INEC. He says the plaintiffs, that is those who claim to have been nominated, because Chekwa Sokore, recall, was claiming to be the presidential candidate. He said the plaintiffs not being nominated or having their name forwarded by the Chief Victor Oye-led committee cannot be deemed valid candidates of the party for the various elective positions they seek. Further, Chief Edozie Njoku, this is a categorical statement by the court. Chief Edozie Njoku is not recognized as the chairman of APGA and so lacks the powers to forward the names of nominated candidates. This was the conclusion of the court, the Federal High Court. Now, thereafter, some factions again, some of his so-called nominated candidates, because this one was for the people who say they were presidential candidate and National Assembly candidates. Another group who claim to be governorship candidates, because like I always say, I say it without any fear or equivocation, for them this is business. These issues always rear its head during primaries. So it's always a business venture for them. Now, another set of some persons, this man, Dr. Michael Emu, claimed to be the governorship candidate of APGA in Delta, nominated by Edozie Njoku. They went and filed another suit. This one now, the cause of action was by governorship candidate and House of Assembly. That's governorship candidate in quotes and House of Assembly candidate in quote, purportedly nominated by Edozie Njoku. This suit was filed before His Lordship Honorable Justice H.A. Ngajiwa of the Anambra State of the Federal High Court, Oka. And the court delivered its judgment again on the 5th day of April, 2023. Now, what did the court say? I'm now at page 22. It says, after reviewing the evidence led, the affidavit of all the parties, and then the document attached, or the exhibit, the court said, first, from the evidence before the court, it is clear that to carefully determine the issue in this suit, this court must first consider if Chief Edozie Njoku is the chairman of the National Executive Committee of the first plaintiff, which is APGA. The question pertinent to ask, therefore, is, will determining whether Chief Edozie Njoku is the chairman of the All Progressive Ghana be delving into the domestic affairs of the first plaintiff? The court said the answer is in the affirmative. That is the decision of the court. Now, going further down, another key part of the court's decision, because, of course, they were basing their contention in this suit on the same corrected Supreme Court ruling of 24th March. This is what the court said. The court said, as opposed to the contention of the plaintiffs, that is the people purportedly nominated by Edozie Njoku, as opposed to the contention of the plaintiff in this suit, the decision of the Supreme Court, this is very key, the decision of the Supreme Court in Exhibit 6 did not, Exhibit 6 in this suit was the corrected Supreme Court ruling. He said the decision of the Supreme Court in Exhibit 6 did not state categorically that the Chief Edozie Njoku-led National Executive Committee are the lawfully nominated executives. Rather, the Superior Court held that determining such an issue falls within the confines of the domestic affairs of the political party, which is not justiciable. Hence, the appeal was dismissed. Now, it means, therefore, that as at the last count, these two Federal High Court judgments, one by Honorable Justice J.K. Omotosho and one by Honorable Justice H.A. Ngajiwa, did state clearly that Edozie Njoku was not the national chairman of APGA. Now, instructively, the Court of Appeal has equally affirmed the decision of Omotosho. Remember, Omotosho was the person that found as a fact that Oye remained the national chairman of APGA. Now, this is what the Court of Appeal said. After, of course, this appeal was dismissed on grounds of jurisdiction. And now, the court further went on as an intermediary court to determine the real issues, because their appeal from the Court of Appeal will get to the Supreme Court, so they have to equally render a decision on the merits. Now, delivering their judgment on the merits, the court said, even if the court has jurisdiction, the court has already determined that it does not have jurisdiction to hear their appeal. Now, the court said, even if the court has jurisdiction, I have very carefully considered all the processes before this court, the originating summons and counter affidavit for and against the appellant case, all the processes in that behalf, the submissions made to the court below, and the judgment, and I agree with the court below that it is right in the dismissal of the case of the second to third appellant, and I too hereby dismiss their case. So when you dismiss the case of the appellant, you affirm the judgment of the lower court. So, as at the last count, on the issue of the then leadership of APGA, the highest judgment then was the judgment of the Court of Appeal, Abuja Division. And of course, by Section 6 of the Constitution of the Federal Republic of Nigeria, the Court of Appeal is a superior court to an FCT High Court. Everybody knows that one. Now, what we do not understand is that in spite of the subsistence of all these judgments, Edozie Njoku and his co-travelers have been running around the FCT High Court before Honorable Justice Madugu. Incidentally, and I say this, even the judgment they are parading, even the judgment of Honorable Justice Madugu, did not at any point state explicitly that Edozie Njoku is the national chairman of APGA. Nowhere will you find it in this judgment. The court equally made a finding that the Supreme Court did not pronounce Edozie Njoku national chairman. Remember, the contention they've been having all along is that the Supreme Court pronounced the national chairman. And they are now relying on the judgment of Honorable Justice Madugu, delivered on the 6th day of June. Let me read what the court said. The court, he said, on the whole, the judgment of the Supreme Court on the 14th October 2021 is to the effect that parties should maintain status quo prior to the institution of the offending action termed as forum shopping and a gross abuse of court process. That is what the court ruled. So they agree, inadvertently or invariably, that the Supreme Court did not pronounce him. Rather, what the court now decided to do was now to construct on his own or interpret. First of all, you remember when they filed this suit, they said it was for the interpretation of the Supreme Court judgment. How laughable. The Supreme Court, the decision of the Supreme Court cannot be subject to interpretation by an inferior court. It's a gross abuse of court process. But of course, as a law-abiding party, one thing I do not do as a lawyer and a minister in the Temple of Justice, I will not sit, of course, and cast aspersions on the personality of a judicial officer. The Constitution of Nigeria has made ample provisions on how a diligent party should handle an unfavorable decision, so to speak. So even if this is an unfavorable decision, the proper forum available to any party is to proceed on appeal. But I must bring out 1, 2, 3 key features of this suit and the judgment. If you look at the parties, you will see that APGA was not a party on record. The first plaintiff here is Otumba Kamara, Latif Ogidan, and Alhaji Rabiu Mustafa. His first defendant is Chief Victor Ikoye. The second defendant is INEC, only 2 defendants. So the court was purporting to reach decisions affecting the interests of a political party, APGA. And the parties before him, or the plaintiff, never cared to join APGA as a party. And this is what the Supreme Court has said in a pretorial decision, that you cannot shave a man's head in his absence. The political party that you are seeking to determine issues pertaining to its leadership, that political party was not even joined as a party. And what they have been doing has been to file different suits with using various proxies. Here, The proxy they used here was Chief Chekwas Okorie and Co. In this suit now, before the Federal High Court in Oka, the proxies they used was one Dr. Michael Emu. I'll make these copies of this judgment available to all of you. And here, they now called one Otumba Kamara Latif Ogida. So they keep going from court to court, which was the same thing the Supreme Court determined in the judgment in question, that what the plaintiffs in Jigawa did was to engage in forum shopping. So they'll go to Federal High Court Abuja, they don't get a favorable judgment, they abandon that court. They go to Federal High Court Oka, they don't get a favorable judgment, they abandon that court. They now come to FCT High Court. Now, what is painful is that, yes, you have delivered the judgment. The parties has exercised their right of appeal. Chief Victor Oye, because I keep saying I have no business with this judgment, incidentally, this judgment was delivered on the 6th day of June 2023. As at the 6th day of June, the rest or the subject matter which the court sought to determine had been destroyed, because Oye's tenure ran from the 31st of May 2019 to the 31st of May 2023. So as at the date the court was purporting to determine issues pertaining to the leadership of Oye, Oye was no longer in office. And I was the national chairman of APGA at that time, and I was not even joined as a party in this suit. APGA was not a party, and we felt for whatever it is worth, let them keep on. This judgment does not affect my tenure as the national chairman of APGA, neither does it affect APGA, because APGA was not a party. And like I said, which is most important, the fact the court did not even pronounce the man who has been parading this judgment. And I don't know, I asked at time whether he has lawyers who should explain the content of a judgment printed in black and white. The judgment of court is a public document. You can go to the registry of the court, apply and get certified true copy. So there is absolutely no prevarication or any ambiguity about the judgment of court. If you look at the orders the court made, the court granted, because the court, they sought some reliefs which the court did not grant. And the court explicitly said, on the whole, judgment is hereby given as follows. He granted orders 1, 2, 3, 4, and 5. And which was to the effect that Oye, occupying his office, contrary to the Supreme Court judgment, is invalid. How? There are already 2 Federal High Court judgments and a Court of Appeal judgment. And this judgment came later in time because it was delivered on the 6th of June 2023. The Federal High Court judgment of Abuja, Justice Omotosho, was delivered on 28th day of March 2023. That of Justice Ngajiwa was delivered on 5th day of April 2023. And importantly, or most importantly, that of the Court of Appeal was delivered on the 2nd day of June. Incidentally, and quite painfully, the attention of the court was drawn to this judgment on the day he wanted to deliver his own judgment. He was told that one of the matters, because then we submitted only Dr. Oye submitted only the judgment of Omotosho. So when he came out to read judgment, he was informed that there is a development, that the Court of Appeal has now delivered a judgment affirming the judgment of Omotosho, which pronounced Oye as the national chairman of APGA. He said that the judgment is not before him. The simple thing would have done would have been to defer to the authority and institution of the Court of Appeal, which is a superior court. And this is what various authorities have termed as judicial impertinence or judicial rascality. It is clear. So a judge of a high court who knows that there is a decision by a superior court is duty-bound to wait and defer. Even if you're not sure, what you would have done would have been counsel. Provide me with a certified true copy of the said judgment. It's very simple. And now, what have they done? What they've done is to still go back to the same court. There are authorities that you cannot be a judge in your cause. It's one of the twin pillars of natural justice. If the proceedings are in respect of a contempt or disobedience to an order you made, the simple thing would have been for you to recuse yourself so that another judge would determine whether there was actually a violation of your order, and not for you to grant an order and still sit in proceedings whether your order has been violated or not. And this takes me to another point, because the contempt proceedings, which according to them, of course, sometime in the course of the proceedings, he did make an interim order, which was to restrain Oye from conducting national convention. I think he made that that pronouncement sometime in May, on the 10th day of May, that Oye should not conduct congresses. Of course, Oye does not conduct congresses of APGA. APGA is a political party. And if you read the provisions of Section 223 of the Constitution of the Federal Republic of Nigeria, it is very clear. Political parties must have a fixed term of office not exceeding 4 years. So on no account, because for Oye to exceed 4 years in office will mean that there has been a gross violation of the ground norm, which is the Constitution of the Federal Republic of Nigeria. It says you cannot stay in office beyond 4 years. Every member of any political party, all the executive officers of a political party, you must have a fixed term of office not exceeding 4 years. So, when the court made the order against Oye, meanwhile, like I said earlier on, APGA was not a party. Now, 2 days after, a High Court of Anambra State delivered a final judgment compelling APGA, because some persons went to court saying that there are plans by Oye not to conduct, or by APGA not to conduct its congresses and national convention, and which will be against the provisions of the Constitution. And the court interpreted the provisions of the Constitution and came to the conclusion that APGA, having admitted that the national officers came into office on the 31st of May, that they are duty-bound to conduct their congresses and convention on or before the same 31st of May 2023, which will be the anniversary of their 4 years in office. A judgment of the Anambra State High Court compelling APGA, and in obedience to that judgment, APGA conducted its congresses and convention. And it is the same convention that the court is now sitting, purporting to hear a contempt charges or a contempt proceedings against Chief Victor Oye and the INEC chairman, when there was actually a judgment of court that they obeyed, clearly. And aside that, there are 2 other judgments of Federal High Court, like I said earlier on, and the judgment of the Court of Appeal on the same issue, pronouncing Oye as the national chairman of APGA. Now, there is a pending appeal, there is a pending motion to stay proceedings. And the same judge, has brazenly decided to ignore all calls for reason and is proceeding. And so the same people who have engaged in gross violation of various subsisting judgments of court are now the ones crying foul to the public, calling on the chairman of INEC to obey which judgment? Does a judgment, a subsequent judgment of a court of coordinate jurisdiction, does it upturn the judgment of a court of another jurisdiction, of coordinate jurisdiction? More so, when the same judgment has now been affirmed by even a superior court. A high court is bound by the judgment of the Court of Appeal and the Supreme Court, even if that judgment is given in error. Even if that is the principle of tarry, you must stand by the decision of the court. You cannot, as a high court, say that the judgment of the Court of Appeal or Supreme Court is wrong or erroneous. What you do, you submit that same judgment to the authority of the Superior Court. They are the only ones that can pronounce on their judgment, if they will abide by it or set it aside. And what Justice Madugu is doing is invariably setting aside the judgment of the Court of Appeal, which is an aberration in all known legal parlance. And so, we'll conclude by saying that we've drawn all these facts for the world to know what is actually happening. We commend, and I say it, I commend INEC for standing with the truth. I commend Professor Mahmoud Yakubu for standing with legality. And my friend, the National Organizing Secretary, has asked a question. Just a very simple question we were discussing, and he said, okay, now, the Supreme Court, the Court of Appeal last week, you all are aware, so Court of Appeal affirmed the election of the governor of Nasarawa State. True or false? Just last week. And then, after that affirmation, a High Court of Akwanga sits and says that the man is not the duly elected national governor of, what is it called? Nasarawa. And orders INEC to issue another person a certificate of return. Do you think INEC will obey such an order? In the face of a superior judgment by the Court of Appeal affirming the same election, the man's election, now a high court, which is an inferior court, now says, no, you are not duly elected. this is the duly elected person issuing it. INEC cannot obey such a judgment. They cannot. They have a moral duty and a legal duty not to obey such a judgment. And that is what happened in this case. There is a Superior Court of Appeal judgment. So you cannot force INEC to ignore a Court of Appeal judgment in preference or difference for a High Court judgment. It's impossible. And so it's for Nigerians to know the truth. It's for Nigerians to know the truth. I don't see what Edozie Njoku is looking for in APGA. There are other political parties in Nigeria. He has the right or the freedom, the unfettered discretion to join any political party of his choice. The tenure he claimed to come into office on the 31st of May 2019. And I've said it severally. If Edozie Njoku can produce a certified true copy from INEC, showing that INEC monitored the convention or the purported convention, or that he issued INEC notice of that convention, I'll step aside for him to take over as the national chairman. If he can produce a certified true copy of an INEC report monitoring the purported convention in Owerri, he has no venue. Absolutely no venue. What we just heard, it was sometime in 2020, they ran to Bauchi to get an order that he's the national chairman. The matter was transferred from Bauchi to Federal High Court before Justice A.R. Mohammed. And A.R. Mohammed said that the issues contained in the suit are the internal affairs of a political party and therefore non-justiciable. Struck out the suit. The next thing, they ran to Jigawa for a convention that was conducted in Owerri. What happened to the High Court of Owerri, or the Federal High Court in Owerri, that has territorial jurisdiction? What happened to showing Nigerians the report of the National Convention monitored by INEC? It's a very simple thing. And like I said at the beginning, the Supreme Court has said that courts do not coronate national chairmen. It is not an ordination. It is an election by members of the National Convention, delegate at the National Convention. And so, like I said, in some, it's for Nigerians to know the truth, to stand by the truth always, because they said, you will always stand by the truth, and the truth shall do what? Set you free. So what we have stated here is the correct position. The document and the judgment are referred to. The certified true copies are here. So I urge Honorable Justice Madugu, in the interest of justice, to recuse himself from hearing the contempt proceedings. And in view of the fact that there is a pending application to stay the contempt proceedings, which I was just informed was undertaken today and adjourned for ruling tomorrow, I don't see a reason why there is an application to stay a proceedings. The appeal has been duly entered. The matter is pending before the Court of Appeal. The authorities are galore that once there is such an application pending before the Court of Appeal, the court should wait and await the outcome of the decision of the Court of Appeal on that issue. Because proceeding with such will mean that you have preempted the decision of the Court of Appeal. Or you may even have the tendency of rendering whatever the Court of Appeal will do helpless. So we call on him to recuse himself from further adjudication in the contempt proceedings. And finally, like I said, I equally commend Professor Mahmood Yakubu, the chairman of INEC, and the entire INEC legal team for standing with the truth, for standing with justice in this case, and for deferring to superior court decisions on APGA leadership. And I urge each and every one of you to always, as much as possible, run background investigation on anything concerning the leadership of any political party, not just APGA. Thank you.
Thank you, National Chairman. We will take only 2 questions.
For anybody that does not really understand, and for the general public, we have 2 publications today. One was published, I think is at page, we have Daily Sun at page 19, if I'm not mistaken. There is a public notice from APGA. This is page 19 of Daily Sun of Monday, 27 November 2023, chronicling everything about what I've just said here, the various judgments, the various decisions of various courts on the issue of whether Oye was removed by the Supreme Court as the national chairman of APGA. So this is for page 19 of Daily Sun. Of course, anybody can just pick up a copy of Daily Sun. And then we'll have another publication, the same publication for those that prefer Vanguard. We'll have it at page 25 of Vanguard. It is still the public notice. And they said, attempt to deceive the general public by Edozie Njoku and his continued campaign of blackmail and calumny against INEC, setting the record straight for clarity. And where we enunciated and enumerated the various decisions or subsisting decisions of various courts on APGA leadership as at date. And in the absence of any question, of course, it means, oh.
It is not a question, clarification.
Yes.
Because sometimes we want to make clarifications and we don't know who